yourself. Give us your testimony.
Good morning, Chairman Hughes, members of the committee. My name is Bryan Blevins. I'm here on behalf of the Texas Trial Lawyers Association and myself, and I'm testifying in opposition to SB27. Mr. Chairman, thank you for your open door and ability to communicate with you about the concerns we have with the bill. And those concerns still remain. We have significant concerns about the constitutionality of the bill, about some procedural inefficiencies, and perhaps some unintended consequences as well. I've provided a response to the Jordan case, which is a case that's currently being touted as constitutionally supportive of this bill, and I've provided a detailed response on that. I've also provided a letter, it's a joint letter from the Texas Association of Defense Counsel, the Texas Trial Lawyers Association, and ABOTA. And I think it's important because there is not a consensus of support for this bill in the legal community. When you have plaintiff lawyers and defense lawyers and really smart lawyers, and they all agree that there are concerns and issues with a particular piece of legislation that is going to radically change the administration of justice in this state, I think that's worthy of note. In addition to that, I myself have had the opportunity to represent many small business claims in our courts. And I can tell you that those include doctors and hospitals to get promptly paid, mineral owners to get properly paid, small businesses over property disputes and insurance disputes. And I can tell you without doubt that some percentage of all of those cases would end up in this court because of the concerns over the jurisdiction, breadth of the jurisdiction in this matter. My clients expressed to me a concern predominantly of why are we having two systems of justice? Why is there one set of justice for big companies with big claims versus my claim? And how am I going to be treated in a court where the predominant players are large businesses and large law firms? My time is out, and those are just a few of our concerns, but we do appreciate the Chairman's willingness to hear those concerns.
Mr. Blevins, thank you. Senator Johnson.
Yes. Thank you, Mr. Chairman. Thank you for testifying, Mr. Blevins. What specifically is your concern about the constitutionality of this proposed statute?
Well, there are several constitutional infirmities. Number one is that it's statewide. Our constitutional Article 5, Section 8 specifically requires that our district courts be divided, and that's why we have divided courts. If you start looking at all the specialty courts that we keep hearing about, almost universally those are divided courts that are already within existing judicial districts. This is a statewide court, so that would be one primary problem. By the way, the Jordan case dealt with the Domestic Relations Court of Potter County, I believe. So it didn't deal with the statewide issue at all. Then you get to the appointed judges, which again, under our Constitution, judges have to be elected, or they can start as appointed and then they have to serve. They're going to continue to serve. They have to be elected. And that's the issue with the Jordan case. The Jordan case is about a statutory court. The court specifically determined it was a statutory court, not a constitutional district court. This is clearly a constitutional district court. It says that specifically in the original bill, and it still says that under 24, the Texas Government Code, which at 24007A says it is a court that is created under Article 5, Section 8 of the Constitution. As a district court, you have to have elected judges, you have to sit the court in the county seat, you have to hold proceedings in the county seat, and you have to have the persons of that district and county vote on those judges.
Do you expect that if this bill passes and a business court in Texas is created pursuant to the statute, that it will be challenged in court?
I absolutely do, because under the committee substitute, you can find your way or find yourself in this court in a number of ways. If you're the plaintiff, you're forcing the defendant to be there if you file the case there. If you're the defendant, the plaintiff originally filed in our existing court system, that defendant can remove you. But now under the committee substitute, a judge can remove both parties against their will into this court system. In 2022, the Texas Judicial Council reviewed this very subject matter. And one of the several recommendations that they made regarding the establishment of business courts is that it be a voluntary, an opt-in. So that's one of the three areas that this establishment doesn't meet those recommendations.
So thinking as a practical matter, and I want to recall the testimony of Mr. Barnes from IBC Bank when he was saying this isn't really a Democrat, Republican, liberal, conservative issue. It's also not a pro-business, anti-business issue. We need to make sure that we proceed in a way that doesn't jeopardize the interests we're trying to protect. So, given that there is likely to be a constitutional challenge to this, if I plead a case and I'm trying a case in these business courts, and 2-3 years from now, their constitutional validity is thrown out, what happens to my case?
Well, I think first you're there and you've either been stayed or every single thing that judge has done, every ruling, every consideration is now thrown into uncertainty. And that's why I understand that the goal of something like a business courts is predictability, but the reality is that the constitutional challenges and the procedural infirmities are going to create uncertainty, not predictability.
You've expressed some concerns earlier about delays being associated with the business courts. What's your issue there?
Well, twofold. One is the constitutional challenges. So you're going to have a constitutional challenge, number one, to which court of appeals we go to. Because if it in fact goes to the 15th Court of Appeals, there are constitutional concerns raised with respect to that bill. So that's number one. Where are we going to go? I think the committee substitute says the Texas Supreme Court, if it's similar to the substitute in the House. That's still going to take a year plus, even with a direct appeal to the Texas Supreme Court. There are cases currently pending at the Texas Supreme Court for years. So we don't know for sure, but one will be the constitutional challenge. That's one basis of delay. The other one is simply a logjam. We heard before, and I'll be absolutely honest, I don't know how the first witness identified that 2% of the docket is going to end up in this court. I've reviewed the Court of Administration statistics on cases, and the fact of the matter is that the data doesn't go deep enough to allow you to identify all of the different cases that will be subject to the jurisdiction of this court. But I can tell you this, there's 133,000 pending contract claims. You just look at contract cases. 133,000 pending in the state. If 2% of those come in, 2%, that's 2,600 cases. That's more than 380 cases per judge, which is almost double the entire number of cases currently pending in the North Carolina business court that the first gentleman touted. So what you're going to have here is a logjam. You're going to have a logjam of cases that are not moving, hanging under a cloud of constitutionality challenge.
In which case the whole notion of an expeditious resolution of business claims is thwarted.
Correct.
Okay. If that's correct. The other thing we've heard about today in testimony is that we've had business courts successfully operating around the country in other states. Is there something we can learn from that model about how we can do it right here, or in fact whether we should do it here?
Well, the first thing you learn when you look at these different courts is there is no model. They're all different. Some of them are as simple as a particular city or county has a business court. The majority of them operate off of elected judges. Those that are appointed, only a handful, are appointed by the governor. The longest appointment that I can find, or the shortest appointment that I can find, is 5 years, getting away from the balance of power issues between the executive branch and the legislative branch that might be implicated by a 2-year judicial appointment period. But I think that if you just look at Delaware, because everyone likes to talk about Delaware and how special.
Can I pause you 1 second, Mr. Blevins? I don't want to get too quickly away from this question of, you said balance of powers. I want to use a different term, separation of powers. And I do fear that we look at certain political ends and ways to get there. And I think over the past years I've seen many instances, and this appears to be another one, where the separation of powers contemplated by the framers of the U.S. Constitution and by the Texas Constitution is starting to erode. And I fear that 2-year appointments by the governor is contributing to that trend.
And in this instance, what it basically means is that a judge who would be in the middle of cases, sitting in pending cases, would have to go and have his or her paper graded by the governor's office of the executive branch in order to then be reappointed to continue that. The opportunity for a balance or a separation to be violated, I think, is considerable when you consider that in many of these instances, litigation will be ongoing and will have been going on for certain periods of time when the governor makes the decision to reappoint or not.
And I apologize. Thank you for pausing on that point. You were discussing models of business courts used in other states.
And I just want to point out Delaware because it is used so often as a model and what we should aspire to. But Delaware is fundamentally different. They've had a constitutional provision since the 1880s that allow for the appointment of judges. It also provides that judicial panel, 5 judges, have to be bipartisan. In other words, there can only be more than one of the other party, two Republicans, 3 Democrats, 3 Republicans, 2 Democrats. That's by law. Those judges, the governor selects from a list that is selected and provided to him or her by a bipartisan committee, and those are the only people that he can appoint. And of course, probably the most significant factor that if I were a business lawyer would say creates predictability in Delaware, they don't have jury trials. So unless you're planning to take away the right of Texans to jury trials, the predictability that the business community would like to have is not going to be served.
Thank you for your thought-provoking testimony, Mr. Blevins.
Thanks for your testimony. Thanks, Senator Middleton. You have questions?
I had a quick question. You said there was going to be a constitutional challenge. Who do you predict will bring that challenge?
It could be any or all. It could be plaintiffs that didn't want to be there, that a defendant has moved there, and there's a jurisdictional dispute. I think you raised in earlier testimony this question of how far down could that $10 million jurisdictional limit go. So if a person gets removed there, says I shouldn't be here, there's a jurisdictional fight over the $10 million, and they lose that ruling will become the basis of the constitutional challenge. A defendant who doesn't like where they are because they've been moved out of their forum selection clause. For instance, in Texas, a lot of defendants have forum selection clauses that say where the case should be tried and brought, not just for trial, but for pretrial purposes as well. So therefore, a defendant where the plaintiff files the case in the business court, they've now been deprived of contractual agreement of where their case was supposed to be filed. They could be bringing the challenge. Or now under the committee substitute, a judge moves both parties against their will, and jointly they're challenging the constitutional aspects.
So you think only the parties that would be subject to this court that have had a case referred to it essentially
Would bring the constitutional challenge?
or can?
No, I don't believe can. I believe it's probably there the most likely. That I believe that if you look at the Constitution, and if the case laws that are reviewing it, the judges, under the Constitution, the judge serves in a district court that is given a specific jurisdiction. It is his or her constitutional obligation to exercise that jurisdiction. If under this bill that judge is being deprived of doing his or her constitutional duty, I'm not sure, but I think legally perhaps they have standing to challenge that.
So a district judge is...
Again, I don't think they would. I don't think they would. I think they may have standing to do so.
Okay, thank you.
Thanks for your testimony. Members, any other questions? Thank you both. And I'll just note on the committee substitute, you mentioned that there's a different House version. The committee substitute before us regarding what happens if the 15th Court of Appeal does not come into existence, the case would be appealed to the Court of Appeals that would have gone to under the previous rule. So if that's helpful, one of the many points we discussed. Thank you both. Thank you very much.